Leona Bennett, and I'm one of the partners here at Southern Waters Legal, and I run the family law team. I'm here with Ainichal from my team. We are creating a segment at the moment where we're answering some frequently asked questions that come up all the time in family law matters. So what question we have today, Ainichal?
How does the court consider property settlement?
Yeah, it's a good question, and it's one that we get asked all the time for any new clients who come in, or people who generally want to have an understanding of what the process is. So when determining property settlement, there isn't a formula that you apply, but there certainly is a methodology. And whether you meet with a family lawyer who's assisting you, or whether you go to a court and a judge has to determine your matter, they adopt that methodology. And it's described as a 5-step process. The first step is to decide, do we divide our assets at all? In some situations, you might have a very short relationship and it might not be appropriate to divide your assets. Most people overcome that first step, and the second then becomes, let's identify what our assets are. Tell us about that.
Yeah, so we go through your statements, we ask for disclosure from the other side, we ask for disclosure from you. It's where you provide us with your financial details, any properties that you own, and then we prepare a balance sheet, and that gets considered as part of the process.
Yeah, and it's actually one of the parts that take longer than some people anticipate, because the value that's attributed to certain assets can require the assistance of other parties, and that might be having a business valued, having a house valued, and then creating that on the balance sheet. The analogy I give clients is that we can't get to the step where we talk about how to divide your piece of pie if we don't know how big the pie is. So that second step becomes really important because we identify what the assets are. The third step then is to consider your respective contributions to the assets. So through the course of your relationship, how did you come to have the assets that you had? And those contributions address financial contributions. What did you have at the outset of the relationship? What did you bring in throughout the relationship by way of your income? And also, did you receive any windfalls throughout the course of your relationship, inheritances or gifts from family members? But it's not just financial contributions we consider, it's also non-financial. Tell us a little bit about that.
So non-financial is, your parenting contributions, your homemaker, your role as a homemaker, and what you've done and taken steps like, renovating the property, that's one of it, or steps of maintaining the property, cleaning the property, looking after it, your role as a homemaker and parenting.
Yeah, and all really important. And the family court was way ahead of itself years ago when it recognised that the homemaker role is considered as important as the income bringer, for want of better words, role. So there's a real recognition that the income earner and the home carer, their contributions might offset each other. And that is something that many clients aren't aware of, or they have a fear when they come in that if they were the stay-at-home parent, that their contributions will be somewhat less recognised, and that's certainly not the case. And then after we've considered the contributions, we go to the step of considering future needs, and we do that in accordance with the section of the Act, which is section 75(2), and we have this consideration of what needs parties might have, and what do we consider, or what questions do we ask clients when they come in when we're addressing that?
Yes, so we generally take into account their education, their qualifications, their age, their capacity to earn, and their health issues, if any, to be considered going forward.
Yeah, I think it's really important to know that if you have a relationship where one partner is earning $200,000 per annum and the other partner is caring for the children primarily post-separation and working part-time and earning $20,000 per annum, the court's going to recognise that the second parent has a greater future need than the first parent by way of their limited ability to earn, potentially because they took time out of the workforce, or potentially because they are caring for children, so their ability to work is somewhat lessened. And then the final step is when you've considered those 4 steps, you get to a point where you think about what is just and equitable, and what would the court consider just and equitable in the circumstances. And that's when we get down to talking about what's a just percentage in your circumstance, taking into account the steps above. So every matter is different. In my 20 years of doing this, we never have people come in with the same story and the same outline, and every person's specific events, their history, what they've got going on in the future is different. So taking that analysis and considering those 5 steps is a really important process in giving people appropriate advice. So if you need some assistance in figuring out what this means for you, if you've separated, and how we can help, please don't hesitate to give us a call here. All right, thank you.